Good afternoon, everybody. Thank you for joining us today for this webinar at the British Institute for International and Comparative Law. The theme of this webinar is Collaborative Resolution of Disputes and COVID-19. In May, we began a discussion at the British Institute for International Law, International Comparative Law, which followed with a virtual meeting that took place on the 7th of April. The point of that meeting, which included Lord Phillips, Lord Neuberger, Sir William Blair, as well as Sir David Edward, the chairman of the British Institute for International Comparative Law, Keith Ruddock, and the director, Spiros Maniatis, was to discuss the legal impact of the pandemic. The former senior judges who were affiliated with BIICL realized very quickly that this was not a time to focus or listen only to the noise and the panic, but rather listen to the silence, to what was not being said about the potential or looming deluge of disputes. The result was a concept note 1, on the effect of the 2020 pandemic on commercial contracts, which followed with another concept note published in May. The concept note, and obviously the second one as well, was widely reported and was intended to begin a conversation to build confidence amongst jurists and legal thinkers to come up with creative solutions and catalyze a discussion for how the bar, the bench, and all of legal London, along with industry, can collaborate to keep commercial life going. Many of us have already thought about the issue, and what we have today is one of many efforts that BIICL plans to conduct. BIICL is a charitable organization, and it is only through the goodwill of supporters and industry and business and friends that we're able to hold important conversations such as this to find innovative solutions. And as a trustee and a member of the Development Council, I urge you to reach out to us or our development team to discuss ways in which you can help BIICL contribute to this wider global recovery conversation through legal means. I would also like to take this opportunity to thank two of our first collaborators, the CEDR, the Center for Effective Dispute Resolution, the Chartered Institute of Arbitrators, who will be telling us about their latest scheme, the Pandemic Business Dispute Resolution Service, as well as IDR, led by Wolf from Kumberg. The whole team at BIICL, especially Liam, who's been helping us conduct this webinar, and making this platform to think through these pressing challenges, as well as Alex Just of Montfort Communications for their tireless efforts. And again, urge you to reach out to them, to Diane Denny at the Development Office to tell us about what are the ways that we can help together to support our fantastic researchers and propose or repurpose expertise that is available at BIICL during these testing times. So as I mentioned, as a result of both concept notes on breathing space, BIICL played a key role in putting the issue of avoiding a deluge of disputes on the agenda of the legal community. And it is clear that we need in-depth comparative research, links to industry, and connections with the legal thought leaders of the world to bring together efforts to ensure the pandemic does not cause a deep and lasting recession. And what we have this in the next hour is going to be we'll start with a brief overview of the Breathing Space project with Dr. Eva Lein, and followed by some comments by Wolf from Kumberg on what businesses need to find a way and how they need to find a way to baseline legal obligations. We will hear from both Katherine and James on the practical applications of conflict resolution options, And finally, by one of the leaders and authors of this project, Sir William Blair, we'll be hearing about the place of arbitration and the courts. So let me start by our first speaker, Dr. Lein, who is a professor at the University of Lausanne. Her fields of expertise are private international law, international dispute resolution, and comparative law. She's also a senior research fellow and director of the Center for Comparative Law and BIICL. She's a qualified German lawyer and fluent in many languages, as well as a visiting professor at Queen Mary University of London. Eva, in the same way as the global medical community has come together to discuss best practices to tackle the health impacts of COVID-19, BIICL is right that now is the time for the global legal community and legal institutions to work in a collaborative and speedy manner. As a comparativist yourself, can you take us through the breathing space initiative and where does comparative law fit with all of this?
Okay, thank you very much, Malik. Yeah, I'm very happy to present the idea of the breathing space project and notably of the concept note 2, which deals with several questions in some more detail. So this idea of breathing space, we consider it under two heads, and the first head is dispute resolution, the second is substantive law, and both heads are looked at from a comparative perspective. So for dispute resolution, we have to realize that unlike any other prior crisis, the judiciary is massively impacted by this pandemic because courts could not work the way they used to work. They could not operate as usual. England and Wales, the judiciary has been very fast in changing to online hearings for some essential cases, so have been other jurisdictions. But courts could not take on all cases, and there will be a backlog of cases waiting for us to be dealt with soon. And then there are all the COVID-19 related disputes that will come up. And unfortunately, this is a crisis of which is unprecedented, and the disputes will concern all different sectors, from transport to insurance to supply chains to employment disputes, and the courts need to face that situation. So there will be an urgent need to avoid placing a strain on the infrastructure of dispute resolution, and we need to think more about constructive solutions, whether we should encourage negotiations, mediation, and alternative forms of dispute resolution, and how to secure that court proceedings can run smoothly. So that is the first topic. The second is substantive law. And what is interesting here, I think, is that contractual disputes will more than usual center around the question of risk assessment and allocation of risk, assumption of risk, and interpretation of contractual and statutory provisions. So there is a need to assess the existing substantive law mechanisms and see if they provide any room for flexibility and solidarity between the parties. And of course, the application of those mechanisms will depend on the particular type of contract and the specific circumstances of the case. But there's a huge interest to consider those two topics from a comparative perspective. We have seen that there are jurisdictions that are more advanced than the UK. We have seen cases start in Asia. So Singapore and China have already provided for certain solutions. So have Germany, France, and Spain, and also New York. So we will look at we looked at the various jurisdictions to find out what they provide as solutions. Note also that the UK Cabinet Office has addressed the question of contract law and dispute resolution in its guidance from the 7th of May, which deals with responsible contractual behavior in the context of the pandemic. And the government is urging the parties to be responsible and fair, both when they ask for performance, when they try to terminate contracts, when they ask for damages and so forth, but also when they commence formal dispute resolution proceedings or when they request mediation or alternative dispute resolution. So this is more or less the framework we have been looking at. And I would like to mention a couple of points we raised in concept note 2 in a bit more detail. The first point is emergency legislation. And I think that is very interesting because there are huge differences across jurisdictions as to the extent of which emergency legislation has been created to give temporary breathing space. And many states have provided punctual solutions in certain areas, often in the area of tenancy contracts. Some states, or many states, have amended insolvency laws to prevent insolvencies or simplify insolvency proceedings in COVID-19 related cases. Some have provided for temporary prohibitions to enforce claims or for extension of statutory deadlines, such as Switzerland or France, for instance. Many regulated travel or events contracts in specific ways. So you can see there have been various punctual initiatives to regulate certain sectors. Some jurisdictions, such as Germany, France, and Spain, have introduced measures on a larger scale that cover various issues of contract law. So they interfere quite a bit with general contract law mechanisms. And I just give you one example, which is Germany. Germany has, in the law of 27th March, introduced the right to refuse performance in certain contracts for consumers and micro enterprises. That is a right that is limited until the end of June, with a possibility to extend that deadline until September. It also regulates consumer credits, provides for a moratorium of 3 months. And what is very interesting, it also encourages the parties to sit down together basically and find alternative solutions and to discuss support measures beyond that limitation of time, so beyond the end of June. So that is quite interesting, and other jurisdictions have provided similar approaches. The problem with the emergency legislation is the interaction with general contract law and also the fact that it is limited in time. But that can also be an advantage where we have the possibility of extending those deadlines, and so that emergency legislation in fact can adapt relatively flexibly to the crisis, and we can extend measures when the crisis is not over. The second point is the application of existing contract law principles. And that is quite interesting as well. So we have on the continent notably the question of force majeure, the question of hardship and change of circumstances, and the potential adaptation of contracts in those situations. And in English law follows very strictly the principle of pacta sunt servanda, but also in English law there are certain mechanisms that we looked at, such as frustration of contract, supervening illegality, material adverse change, implied termed, and so forth. So I only mention 3 of them because I don't have the time to talk about more. I find quite interesting the discussion about force majeure. It's interesting as well for English law because many contracts contain force majeure clauses. Force majeure is defined very differently in contracts and statutory provisions. Some refer to pandemics specifically, some refer to acts of God, some refer to restrictions put in place by government. So first of all, we have to see whether we in fact have a force majeure event in the concrete case, and there needs also to be a causal link between, for instance, a specific restriction and the impossibility to perform. It's quite interesting that many jurisdictions have provided for force majeure certificates, such as Italy and China, which are issued by chambers of commerce, for instance, and say that local companies basically were unable to perform their contractual obligations. It is tricky to assess the nature of those certificates, also the role they might play in other jurisdictions, and we have to be careful that in each individual case we carefully assess whether really there has been a force majeure in between the parties of that specific contractual relationship. It's also interesting that in some jurisdictions, for instance in Spain, there has been a case where force majeure has been approved, although the performance of the contract could still have been possible because of the huge effect of a pandemic that is declared by the World Health Organization. We also see currently cases in France, for instance, where COVID-19 has already been qualified as a force majeure event. So this is a discussion that is ongoing already on the continent. What is also interesting—
a quick question about this, Eva, and I can come back to the other points. It seems to me you're like almost a data scientist right now, looking at all of these jurisdictions, developing so many interesting new innovations. But for a lay person such as myself, have we ever seen something like this legally before?
What have you never?
19.
No, of course. And this is actually the question. So, I mean, what we are trying to figure out is how different jurisdictions assess the situation of COVID-19. And I show you one example now as well of Spain, where it has been made very clear that this is a very specific situation that requires a very flexible approach. So of course we know all those different contract law mechanisms from before, but we have to see how are they going to apply it in the concrete case. And it's quite interesting. There are different rules on fundamental change of circumstance that lead to either the adaptation of contracts or the termination of contracts. And there has been a recent case in Spain where the doctrine of clausula rebus sextantibus has been applied to a COVID case. So that is a case where a large Spanish steel group asked the court to prevent a group of syndicated banks from activating a clause of immediate repayment of a massive loan. And the question was how to deal with this case in the situation of COVID-19. And the court has said this is an exceptional and unprecedented situation because that crisis has paralyzed the world economy. And it's quite interesting that the court actually said it is necessary to adapt contract law institutions to the social reality of the moment. So they have acknowledged the fact that we might need to be even more flexible than we used to because that situation has never occurred before. And I mean, that question, it will be raised before the English courts as well when we think about English contract law mechanisms such as frustration. We all know that the effect of frustration is to release parties from their obligations, and that is a principle that is, of course, not to be lightly invoked, but limited to instances of a virtually cataclysmic event. And of course, we can say this is just that. This crisis is just such an event.
Well, thank you, Eva, for that very, very, very helpful background. I'm sure we're going to come back to the points that you raised, if you will allow me, just in the interest of time. Wolf, I'm going to introduce you in a second, and I want you to just think about frustration, unprecedented, and as well as force majeure. But the real question is about whether or not economically, in terms of business, we've seen anything like this. So Wolf von Kumberg is a practicing lawyer who had experience for over 30 years in international law, compliance, conflict management, and business experience. His last general counsel position was legal director and assistant general counsel to Northrop Grumman Corporation out of the London office. In his roles, Wolf was responsible for all international legal activities across Europe and the Middle East and Africa, which included corporate governance, developing a dispute management process, ADR and CSR policies, investigations, compliance guidelines, and international dispute and compliance clauses. He was past chairman of the Board of Management of the Chartered Institute of Arbitrators, chairman and then director of the International Mediation Institute, interim chair and currently director of CEDR and current director of the American Arbitration Association. So, Wolf, from your perspective, what about business and commercial life today?
Thank you very much, Malik. And as Eva has already set the scene of what business is currently going through, I mean, as Malik said, I spent 30 years in business, but I've never seen anything like this. And colleagues that I'm speaking to in various law departments are just scrambling to deal with issues as they're arising and have very little time to even effectively look at what things will look like in the future. My view certainly is that future contractual relationships will change. Companies will have to start acting more collaboratively with their stakeholders, customers, suppliers inside the company, their employees. I think there's a sea change going on in business at the moment, and we'll see this emerging as time goes on. Very important, as Eva said, is because of all of the conflicts and the disputes that will eventually arise out of this, we'll also have to look at more collaborative ways to deal with these commercial disputes. And I think that's where what BIICL is doing is extremely important because it is being a catalyst and a thought leader in looking at ways to deal with these issues more collaboratively. Clearly, the courts are, as was already said, going to be swamped. And in many cases, the courts aren't really the right institution to deal with these issues. I think as the concept note itself recognized, there are many contracts that are currently affected by COVID that simply have to be renegotiated at this point in time and not terminated. So the courts really are not the right place for renegotiations to take place. So we have to look at other places where contract baseline and businesses can be assisted in doing that. I think as businesses start to emerge out of the COVID-19 crisis, and as they start to look at their legal relationships and the problems they currently face, they're also going to be looking at how they can perhaps create more robust dispute management systems in the future. And here, Eva has already pointed to a couple of guidelines that have been produced. Certainly, BIICL itself, through its 2 concept notes, has played an important role. Eva also spoke to the Cabinet Office Guidance on Responsible Contracting of the 7th of May. And I really urge everybody to read that because it's an extremely well thought through document. While it's only a guidance note, of course, and has no legally binding effect, it does provide, I think, a framework for how businesses should be dealing with their disputes currently and perhaps going forward. And really what the guidance note is speaking to is responsible and fair behavior in contracts. And that's perhaps easy to say, but the guidance note goes on to say that these disputes should be dealt with through negotiation, mediation, or other alternative or fast-track dispute resolution mechanisms before these escalate into formal intractable disputes. If you analyze that carefully, there is a lot of thought being put into dealing with these issues now, not waiting until courts reopen and then trying to litigate those, because in many cases there are relationships with stakeholders that are critical for the survival of these businesses, and those relationships have to continue. So there have to be mechanisms that allow the issue to be discussed and resolved, but that relationship to continue. And that will hardly be the case if these matters are all litigated. Just keeping those guidelines in mind, then very quickly, there are a few points that I wanted to make that businesses should perhaps be looking at now as they emerge and look at their future contractual relationships. The first thing is really to look at what's happened forensically and just to review the conflict points that have arisen out of COVID-19 to see how those might be better dealt with in contractual terms. In particular, going forward, looking at the drafting of model dispute clauses to avoid the risks that have come out of COVID-19. And that clearly also includes looking at conflict resolution mechanisms and tools. I think contracts going forward will have more collaborative means inserted in them for amending essential terms, because we know things like schedule, pricing, payment have clearly all been affected by COVID-19. What's required now is for those particular clauses to be amended in some way. And if that were already built into the contractual terms, then that will be easier to deal with in the future. One very important point there is, of course, when an impasse occurs, when parties try to negotiate, amendments, it's important to have some type of neutral mechanism built in where a neutral can perhaps assist with that contract renegotiation, because as we know from mediation, the use of the neutral is a very effective way of helping parties to get to a resolution without having to impose a solution on them, which is what courts or arbitration do. Training is very important here as well. So going forward, training employees, but also other stakeholders in effective communication and collaborative conflict management will be important. And then just looking quickly at some of the ADR tools that can be utilized by businesses and built into contracts to help to resolve these types of issues as they arise. Structured negotiations with a neutral, as I already mentioned, project mediation, where you build mediation into a project and have a neutral available to you if issues arise. It's very similar to dispute boards, which have been used very effectively on infrastructure projects, where there's a neutral body of people that can be turned to if an issue arises to help to resolve the dispute. Expert determinations, which of course have been used in certain types of industries, but can be perhaps looked at again to see how they might effectively be used more frequently when technical issues arise. Mediation certainly, but perhaps mediation at a much earlier stage than what we have been used to in the past. So rather than issuing proceedings, perhaps looking at mediation even prior to that. And certainly with the current issues arising out of COVID, mediation is being looked at much earlier. And then early neutral evaluation, which can also be a very effective tool where somebody actually gives a non-binding opinion on parties' positions so that they can go off and try to negotiate a resolution. The other thing I think that could be very useful for businesses to concentrate on is creating internal policies, ADR guidelines, for example, for the business, which helps the non-legal employees to deal with contract negotiations and program management and understand how ADR tools might be built into contracts and program management. Then lastly, which is what we're all using now, is the effective use of online platforms. And I know there's been some discussion about that already with respect to perhaps the courts and virtual hearings, certainly in arbitrations. I'm talking to a lot of people who are already utilizing online platforms for virtual arbitrations, and certainly mediations. And I'm sure that James can speak more to that later, but it's a very effective platform for mediating, and in many ways perhaps has advantages over face-to-face mediation. So I guess the last point I would just make is that for business at the moment, if people say that, you know, what we're advocating here isn't really justice, I've got to say that from a business perspective, I don't think businesses at the moment are necessarily looking for justice. What they're looking for is a resolution. I think that's what we should be offering people, is a resolution to their current issues. So thank you very much, Malik.
Thank you, Wolf, for this very helpful and sort of tour de force of where business, supply chains, the economy is right now. It's exactly this effort of trying to thread these things together that we're trying to do here and work together. Speaking of which, I'm going to talk about our next two speakers whom I'll introduce together, representing the Chartered Institute and CEDR. I'm a proud fellow of the Chartered Institute, and I'm also a proud mediator of CEDR. But I have to confess, I never thought, certainly not in my lifetime as a practitioner to see the words or the worlds of mediators and arbitrators truly fuse, in the sense that it's going to be done in application. And I do hope that our colleagues, lawyers all across, understand that this is indeed a moment for resolution, as you said, not prolonging conflicts for personal gains and practice. So I hope that this is not something too controversial that I'm recommending, but it is an important mindset to have. So CEDR and the Chartered Institute work collectively on as a result of the call that was made by BIICL on a pandemic business dispute resolution service, which was created to enable businesses to resolve disputes arising from the pandemic using effective ways and cost-effective ways, and specifically online and quickly. And with the aim of bringing businesses back to work, offering businesses 3 options, including facilitated contract renegotiation, mediation, or fast-track arbitration. The service scheme is meant specifically, or is more targeted towards small and medium enterprises. It doesn't address every answer that is out there, but certainly is a good precedent. I'm very excited to have Katherine Dixon with us, who joined as Managing Director at the Chartered Institute in May 2020, having just completed a world record-breaking circumnavigation of the world on a pandemic. So what an exciting life she started, very timely, and only to sort of come back to this next circumnavigation effort through the legal world. She's led so many interesting roles, including within the NHS, understands the medical world very well, dispute resolution, and she happens to be an MBA, which is exactly what we need these days. I also have my friend and teacher, James South, who is the Managing Director of CEDR, and certainly during his lifetime transformed CEDR's outlook into a more international mediation hub, which I think was very important in exporting UK expertise in terms of dispute resolution. His latest efforts include the World Bank, the Belt and Road Initiative, and other multilateral organizations. So let me start with Katherine, and I just ask you, Katherine, to tell me a little bit about the context and the reason for this scheme.
Thank you, Malik. And so I guess the context is obviously the pandemic, and there's an opportunity, I think, for two of the sort of largest ADR organisations, certainly in the UK, to come together and really look at formulating a solution, and hopefully that's what we've done. So we've created a service. It's called the as you introduced, the Pandemic Business Disputes Resolution Service, and it's really aimed at business to enable them to effectively resolve disputes arising from the pandemic using ADR, so alternative dispute resolution. And it pulls on the guidance that was in the breathing space concept note. So it's looking at facilitating businesses to recover from the pandemic quickly, preserving relationships wherever that's possible, keeping the cost down, and really giving some business certainty as quickly as possible, given this sort of unprecedented circumstances. And also, though we'd actually pulled the service together prior to the Cabinet Office guidance that Wolf mentioned coming out, when I've actually read through that guidance, I think the service very much does answer some of the things that government's recommending, particularly around using negotiation, mediation, and fast-track ADR to resolve disputes quickly. So, as you said, it's an online service at a fixed cost. It gives business access to experts quickly, so they are expert dispute resolvers, and there's 3 options: facilitated contract renegotiation, where you've got a neutral helping both parties renegotiate; mediation, and and or fast track arbitration. So businesses can kind of select one of those, or they could even work their way through all three should they wish. As I say, it is online. You know, we're looking at really sort of targeting probably small, medium-sized businesses certainly in the areas which have been most affected by the pandemic, and you know, we're hoping that to get the word out there that it's available for business, and certainly speaking to lots of business membership organisations, and you know, are pulling on our ADR community as well, so that business know there's a service there to support them.
Malik,
I think you're on mute, Malik.
Thank you very much, Katherine. This was quite helpful to think about and conceptualize, and I think it takes me back to asking James, I mean, the idea of effectiveness in terms of dispute resolution. You think we finally moved in a world where practitioners like arbitrators and mediators now are going to a world that's not looking at the controversial sort of litigant mentality, but rather facilitated negotiation? What are the practical effects of all of this?
I mean, I think actually that trend's been happening before this pandemic. You know, I've been working in the mediation field for a long time, but I've definitely seen moves in the recent past for the arbitration and mediation communities to come more together. And I think when this idea from the Breathing Spaces initiative was brought to our attention, to Katherine and I mean, we both immediately saw on behalf of our organizations that now was the time to send a message to our communities, but also to society generally, that, you know, we need to collaborate in order to provide solutions for the pandemic. And yeah, sure, CEDR could have provided mediation separately and challenged to the arbitrations. But one of the things I think we wanted to do was to provide clarity and keep it simple to businesses, because building on what Wolf said, you know, businesses now are faced with a lot of issues to deal with, and they need clarity about how to address them. So we've sort of developed a one-stop shop approach, and it didn't matter who you go to and where you go to, but one hub to be able to access all these services. So to get away from mediation or arbitration, but well, here's the dispute resolution hub. You choose what you want to pick up. A couple other points on effectiveness. I mean, I think we really were focused on, you know, as Will said, the business needs. Picking up Eva's point about force majeure, I've been in a number of mediations where force majeure has been argued in the past. And while it's fascinating for the lawyers, the parties find it intensely frustrating because they don't really care about the law of force majeure. They just want their issues resolved. And that was the case before the pandemic. I think even more so now as we come out of it, when what businesses are focusing on is revenue generation and managing their cost base. So they want to be able to get these solutions, you know, these emerging disputes nipped in the bud quickly. So it's really crucial now more than ever that these disputes don't get escalated to the courts unless they really need to. I mean, of course, there will always be a place for the courts, and of course, some cases will need to go there, but there will be many, particularly small disputes, that can be dealt with through the other dispute resolution processes. So we were focused very much on that as well. I think the other final point that I would make is just in terms of thinking about effectiveness in terms of online and face-to-face. As Katherine said, we were focused on how do we make this simple and easy to use, and one of the answers to that now is online. There has been clearly a shift, a sea change in people's view about working and doing things online because we're being forced through circumstances. Now, of course, it will go back to more face-to-face work, but mediation, for example, has proved to be very successful online in the last three months. And the cases that we're doing at CEDR, settlement rate is actually higher than face-to-face, interestingly enough. Mediations I've done have actually finished more quickly because the environment of online focuses people's minds. and then somehow levels the playing field. So parties on mediations at least feel more able to engage because they're not in some lawyer's office or ADR institution's office, but they're actually in their living room with a cup of tea and their cat walking across the screen. So they're more relaxed. The playing field's leveled up. So the engagement is higher. So I'm sure the same as in fast track arbitration, similar things in online arbitration, similar things are true as well. So I think they're having that facility where people now are used to it and can access it quickly without having to schlep into central London or wherever it may be, I think is going to make a big difference and make it feel the parties more effective and much more accessible. And those are the things that we were, Chartered Institute and CEDR were really focusing on when we developed the service.
Thank you so much, James, for that capturing the moment of what's actually happening and what users are looking to. I want to introduce our last, but certainly not least, our distinguished judge and member of various bodies within BIICL, Sir William Blair, who's a former judge of London's Commercial Court and is now a member of the International Advisory and Dispute Resolution Unit, IADRU, at 3VB Chambers in London. He's Professor of Financial Law and Ethics at Queen Mary University of London, and he is known globally to all of us, of course, in the field of financial law and other commercial matters, including setting up and being involved with dispute resolution infrastructure and arbitration in the Middle East, China, and elsewhere. He combines mediation and arbitration expertise. He's the chair of the Bank of England's Enforcement Decision Making Committee and chairs the Law and Ethics in Finance Project, which is an informal group concerned with raising standards in the financial sector. He was also the first president of the Board of Appeal of the European Supervisory Authorities, chairs the Monetary Law Committee of the International Law Association, and is an honorary senior fellow here at BIICL. Bill is a member of the Ethics Committee of Digital Catapult's AI Machine Intelligence Garage, which is very relevant as we're thinking and hearing more about this digital space that all panelists have mentioned. Bill, can I kindly ask you to tell us a little bit about Concept Note 2 and what did you identify as ways to avoid a plethora of defaults?
Well, thank you very much, Malik, and thank you to BIICL. And also thank you to everyone who's joined this webinar. I don't know what it's like where you are, but where I am this afternoon in central London, it is very hot. But it's a real pleasure to be here. I know we're a little bit short of time, so I'm going to curtail my remarks and just pick out a few points, if I may. First, what were we trying to look at in this BIICL study? And as Eva Lein has said, we were focusing on international commercial contracts. And why were we doing that? Well, because that's the driver of international commerce. And many people have said, and we certainly believe, that the risk of a plethora of disputes, or as Mario Draghi called it, a plethora of defaults, clogging up the system when we should be focusing on recovery, is something that we have to avoid if we possibly can. And that really is what this project at BIICL is all about. Let me address one point first, which is, do we see a plethora of disputes presently? And statistics, as always, are quite hard to come by, but I think so far as our experience is concerned, the answer to that would be no, we don't at present. I'll suggest a reason for that in a moment, but let me give you some statistics first. I'm looking at the London Commercial Court, and this is as of 15th of June. There's been a slight increase in the number of actions commenced over the past 3 months compared with the corresponding period last year, so a slight increase. There's nothing, by the way, to show that the composition of those disputes has changed. The number of hearings is comparable to the same period last year, but there's an interesting qualification to that, which is that the number of settled trials has considerably increased, and the numbers are about 75% compared with about 60 to 65% in previous years. So far as that part of commercial dispute resolution is concerned, in a way, there doesn't seem to have been, doesn't seem presently at any rate, to be a risk of backlog. Arbitration, of course, as we all know, is a confidential process. We won't get the statistics from the arbitration bodies until the end of the year, but certainly, anecdotally, there have been a considerable number of new arbitrations filed. I think we can probably say reasonably clearly that the number has gone up, but no avalanche yet. And why? Well, the answer, I'm sure, is that business is presently more concerned with just getting through this pandemic and coming out of the other end than getting involved in legal disputes. So let me we've been having a very good general discussion, but let me try to make a little more specific what we're trying to say in our concept notes. And I'm just going to take a very, very ordinary commercial transaction. Suppose you have a delivery under a contract for the sale of equipment, and that's due to be delivered in mid-July. But due to the pandemic, the suppliers of an essential component can't deliver it until mid-August. Can the buyers rescind the contract for late delivery, or can the suppliers say, you should give me a short extension to deliver the equipment because I'm going to be able to do it very soon, and these are emergency situations and you've got to take that into account. Just to pick up something that Eva said, if I may, she rightly talked about emergency legislation in various different countries. Now, here's a point to bear in mind about that legislation. It's usually aimed at SMEs. In fact, the German legislation is even more specific. It's aimed at businesses of 10 people or less. So we're not really talking about the kind of contracts that we're concerned with here. Now, what's the answer to the question that I put? And I'll obviously begin with the usual health warning. It depends on the facts. It depends on the terms of the contract. And at least so far as English law is concerned, we've always taken a very commercial approach to these things. And by the way, in our project, we believe in taking a very commercial approach too. That is what we are about. But we also believe, and I'm picking up the words here of the managing director of the IMF, we also believe that this is a crisis like no other. And that was one of the titles of the IMF quarterly review that came out on Wednesday. They got such a huge amount of attention. Now, a crisis like no other, as the CEO of the IMF has said, deserves a response like no other. And as Lord Neuberger said when he was introducing the this concept back in April, it's our responsibility in the law to rise to the challenge. Now, very quickly, what are we saying? Well, first, we're saying that where contracts are viable, then the emphasis should be made on making those contracts work. Secondly, if they're not viable, then we should be focusing on an equitable solution to bring the contracts to an end. And the law of frustration in this country right now is not necessarily ideal in that respect. Now, how are we saying this is to be done? obviously we're encouraging negotiation. We're saying the parties should try to agree. But you've got to be very careful not to put something like that forward as a kind of a dog that never barks. So there's got to be something behind it. And what we suggested as a matter of law is that firstly, under settled legal principles, the courts should be open to finding implied terms in certain cases, obliging a party to allow a short breathing space. Now that might be the exception rather than the rule, but it would give out a very important message, we believe. Secondly, we think the courts have got to be very slow in finding that parties have waived their contractual obligations by entering into the kind of discussions that everyone who's spoken so far strongly believes in. And then thirdly, Wolf mentioned contractual mechanisms. He's absolutely right to do that. They will often impose things like good faith negotiations, but we also believe that, to put it in a few words, the time of mediation has come. And we think that although commercially the courts in this country have been very slow to require mediation unless the parties actually agree to it, we think that we've really got to look at that again. Now, just a few other things. I'm not going to say anything about on online hearings. Definitely that's going to become much more important. I would though say, and this is from my personal experience, I may say, that the technical difficulties should not be underestimated. It's quite easy to talk about them, but unless you've actually had to grapple with files of thousands of documents in a complex dispute, which some of us have, then it's you'll understand what I'm getting at. There's quite a long way to go before we get the kind of seamless results that you can get in courts or arbitral tribunals or in face-to-face mediations. Just on face-to-face mediations, I strongly welcome the initiative of the Chartered Institute of Arbitrators and CEDR. I think you've done a brilliant job. I particularly liked, and I think Malik picked this out, the idea of facilitated contract negotiations. I think that is exactly the kind of thing we should be doing. Let me mention the London Chamber of Arbitration and Mediation was launched a few weeks ago, and it has a similar scheme. They're going to use blockchain in their administration. And then really one last point, and then I'm going to have to hand it back. We are not saying, totally not saying, that parties should not be going to court. Of course, they're going to have to go to court. They're going to have to arbitrate. These disputes are going to have to be resolved. They can't all be negotiated away. They shouldn't all be negotiated away. And a very, very good example of that is the test case that the FCA has brought to the financial list on business interruption. If I may say this, because I had a hand in setting up the financial list, this is the first time that the financial markets test case scheme has been used. We set it up in 2016. This is the first time it's been used. It's an innovation, and this is a time for innovation. Thank you very much.
Thank you very much, Sir William. This is a very helpful underlying of the situation as we see it. And I think that since we're short of time, and I want to recognize we have excellent questions by Tom Valley, Naina Gupta, James Kwanchu, but you've answered some of them already. What I want to do is, before we end this session, is to give everyone an opportunity to say a lightning round, if you may, sort of a response, with the intention and with the idea that hopefully BIICL will hold another series of perhaps working groups or brainstorming sessions, because this has been very helpful. And specifically in the tagline, the point about specific legal and judicial collaborative approaches being identified. Wolf mentioned this to me. I think that it was so helpful to hear Lord Newberger make a comment, and I'm sure everyone will agree, just hearing the analysis behind what you have just sort of explained is helpful for legal lawyers and general counsels in the future to think about how they consider their approaches. So can I start with Eva and go down the line after that with Wolf, then Katherine, then James, and with you, Sonia.
I think I just want to make a few comments on what comes next at BIICL following this project, because obviously we continue the conversation that we already had before and today. We also were thinking that we should host discussions about a potential voluntary code of conduct, which aims at addressing how businesses approach contractual issues and litigation in current times. So I think that's quite an important discussion. And we would actually encourage representatives of businesses and lawyers to get involved in this discussion. And we would also look more broadly at procedural innovation following this crisis, and we'll launch a forum on procedural innovation, which involves a colleague from BIICL Hong Kong, Chan Bao, who will address potential reform of ADR and look at different ADR mechanisms and how they work well or not so well in the current pandemic.
Yeah, thank you, Malik. I think very important as we continue this discussion is to get more business leaders involved in it. Clearly, it's business that has to appreciate and help with the resolution of what is currently ongoing. I think, as Sir William said, this is a global issue and it's a global crisis. And we have to deal with it globally. And I think it's very important to be inclusive here and get as many of the international business leaders involved in this discussion.
Katherine.
I think we've certainly approached this from the point of view of what do we need to do to assist business, because, you know, cash is king. Many of the businesses are really sort of struggling from an economic perspective, and if they're then faced with a long and costly and time-consuming dispute, I think, you know, many of them won't survive that. And I think what they're looking for is that sort of fast, effective resolution. And I think ADR lends itself very well to that. And that's not saying that there isn't a place for the courts, because clearly there is. But I think for many businesses at the moment, they're looking to really sort of focus on getting themselves back up and running, and disputes are going to be a distraction from them. And we hope that the service that we're offering will give them that breathing space and enable them to continue through what is an unprecedented, difficult time.
James? You're muted.
I think in terms of next steps to gain traction here, I think the past has shown us, particularly in relation to mediation, and I think in terms of fast track or arbitration services, getting some traction with sectors or particular industries or dispute types has proven the most successful in terms of addressing a large number of types of disputes. So, you know, an example, the medical negligence, clinical negligence area now mediates regularly cases of those types, for example. Setting up the business banking resolution service, the dispute resolution mechanism for banking disputes coming out of the previous economic crisis. And it's all those sort of initiatives. So I think thinking about sectors where particularly they are going to need help following the fallout from the pandemic, and seeing if there can be a sector-wide approach rather than a ad hoc case-by-case approach. And I think the courts also play a part in that too. The courts thinking about, you know, how can they help cases being referred to the courts into these other processes.
Sir William, so as we continue to define or redefine ourselves here in the United Kingdom and legal London in terms of the international law in the world, following Brexit and now the pandemic, what are the wise words that you would leave us with?
Well, I'm not sure they're wise words, Malik, but in all other crises and all other economic crises, although there's never been one like this before, as we've all said, but what has been key in getting out has been the restoration of confidence. And whatever else the law does, the law has to play its part in that. And I agree with everything that's been said, and I believe the law will play a part in it.
Thank you very much. Thank you to all of our panelists for this wonderful webinar, and to BIICL once again. And we look forward to holding more of these events in the future. Have a good afternoon.